So I'd like to take a moment to thank everyone who is joining us here today. I am Sean McShay, the Assistant Dean for the Law School for Admissions and Financial Aid here at Boston College Law School, and I'm super excited to have you here with us today. So I'm really excited to welcome you for week 2 of our Admitted Student Week. This afternoon, you're in for quite a treat. We have one of our law faculty members who traditionally teaches in the first year experience, who's happy to provide you with a criminal law class. So at this time, please, give a warm welcome to Professor Stephen Arick Coe, and welcome to criminal law at BC Law. Thank you so much.
Thank you, Dean McShay, and welcome everyone. I'm going to share my screen. So as Dean McShay said, my name is Professor Coe, and this is an introduction to criminal law. Allison Sherwood, are you there? Allison, if you're there, can you unmute yourself?
Yeah, I'm here.
Hi, Allison. Allison, I can't see you on the video. Can you show yourself on the video, or is that not possible for you right now?
I should be able to. Sorry about that.
Okay, great. Allison, I want to open by asking you a question. I'm having a dispute with my next door neighbor. He's playing music too loudly. So I decide that I'm going to kill him. I go out, I get a gun, and then I walk over. I decide on the day I'm going to do it, and then I walk next door, I pull out the gun, I shoot him in the head, and he dies. Have I done something morally wrong?
Yeah, I'd say so.
Why?
You took another man's life.
Took another man's life. That's something that's morally wrong. Cooper Lerner, you agree with that?
Absolutely, and you did it in a premeditated way.
I did in a premeditated way. So in your conception, Cooper, is this murder?
Absolutely.
What's your definition of murder?
My definition of murder would be killing another person in a premeditated way. So you planned to do this, you took the action.
So what if, so it has to be premeditated? What if I just spontaneously decided to kill my neighbor? Then it wouldn't be murder?
I'd say it would be, I actually don't know.
Okay. Jelana Torres, you agree that's murder? And
Yes,
I've done something morally wrong?
Yes.
Should I be punished for that wrong?
Yeah, I would say so, just because like Cooper said, it was premeditated.
It was premeditated. How much punishment do you think is appropriate?
For murdering somebody, I don't know, maybe like 5 to 10 years in prison.
5 to 10 years in prison. So you think after 10 years, I can be back out on the streets?
Yeah, depending on like what you did in prison to reform yourself.
Okay, all right. So maybe there's a question of reformation and rehabilitation in criminal law. Grace Bear.
Yeah.
Hi, Grace. So
Hi.
Same facts as initially. My neighbor is playing music too loudly. I decide I'm going to kill him. I go out, I buy the gun. I'm walking next door and I see a police car. So I turn back and go home and nothing happens to my neighbor. Have I done something morally wrong?
No,
Why not?
because you didn't see the action through.
I didn't see the action through. So you think it's morally appropriate behavior for me to walk to my neighbor's house with a gun intending to kill him? That's morally okay?
Okay, maybe not. No, it's not okay.
Okay, so it's not okay. Okay. Seung-Hae Yang, do you agree with that?
I agree.
So it's morally inappropriate behavior. Have I committed murder?
No.
Why not?
Well, you didn't go in and kill him, right?
I didn't go in and kill him. So I've done something morally wrong, but I haven't committed murder. Ryan O'Malley, should I be punished for this? I didn't commit murder, but I did something morally problematic.
Yes, you should be punished for attempted murder.
For attempted murder, how much punishment is appropriate for attempted murder, you think?
It depends on your mental faculties.
Okay, well, you know my mental faculties now after seeing me for a couple of minutes. What do you think the appropriate punishment is for me?
The appropriate punishment would be a jury trial.
But that's not a punishment. I'm talking about years imprisonment. So we heard previously from Jelana, 5 to 10 years. Would you give me more or less than 5 to 10 years?
I believe that 5 to 10 years sounds appropriate.
Okay, so you think I should be punished the same amount as if I had gone over and pulled the trigger and killed him? You think that's right?
No, I think that if you actually killed him, you should be tried for more than 5 to 10 years.
I see. Okay, I see. So you have a different conception of punishment than Jelana does. I'm going to launch a poll now. Can people see this? Is punishment appropriate in this case? Should I be punished at all?
Sorry, is this in the second case?
In the second case. I'm talking about the second case right now. Yeah. And I know none of you, this is all just testing your intuition to bring you into what I think is the most interesting area of the law, the criminal law. Okay, we have 91% voting. A few more people want to jump in on this. It's completely anonymous. I'll never check afterwards. So let's see here. We had a very interesting split, very, very close. Some people thought punishment was appropriate in this case. Some people did not, and 14% of us were unsure. Two more hypotheticals. Nicholas Russell. You there, Nicholas?
Yeah, I'm here.
So same initial fact pattern. Can you turn your video on, Nicholas, or is that too difficult for you right now?
I'm sorry, I'm at work right now, so I can't.
Okay, all right, no problem, no problem. We'll do it this way. We'll do it this way. So same fact pattern. My next door neighbor is playing music too loudly. I decided I'm going to kill my next door neighbor. But instead of me going to the next door neighbor's house and killing the next door neighbor, I go out and I ask my friend to kill my neighbor. And I pick my friend up in a car. I drive him to the house. My friend gets out of the car that I've driven, kills the neighbor, gets back in the car, and we drive away. Same 3 questions for you now, Nicholas. Have I done something morally wrong? Have I committed murder? Should I be punished?
I think, yes, you've done something morally wrong. And yes, you should be punished, though I'm not sure that you committed murder. I think that you are certainly an accessory to the murder.
Okay, so you think I'm an accessory to the murder. There's something different here, and I've done something morally wrong. And how much punishment do you think is appropriate here, Nicholas? We've heard 5 to 10 years for murder. We've heard also someone say less than 5 to 10 years for attempted murder.
I mean, I guess I would probably say you should be put away for longer than that. Honestly, okay. Maybe I'm a little bit more strict on that, but I think that 5 to 10 years would be the minimum amount for
being. So 5 to 10 years minimum. Okay, and I've got the poll open again here. I want to see if punishment is appropriate in this case. I'll just give this another minute here, and then I'll move on to the final hypo before I move away from this. We had a whopping 96% of people say punishment is appropriate in this case. And Nicholas, you think that's right? Your classmates agree with you?
Yes.
Okay, great. All right, why don't we move on to one final one here, one final hypothetical of our 4. I have a serious psychiatric disorder. I'm a paranoid schizophrenic. The voices in my head tell me that, that I should kill my next door neighbor. So I go next door, I take out a gun, I pull the trigger, and I kill the neighbor. Lauren McCarthy?
I'm here.
Lawrence, excuse me. Is that appropriate? Is that, did I do something morally wrong? Did I commit murder? Should I be punished?
You did commit murder. I don't know if you should be punished or maybe rehabilitated. I would say it's morally wrong objectively, but I don't think that person thought in the moment it was morally wrong.
Yeah, so maybe I did something morally wrong, and maybe technically it's murder, but maybe I should not be punished punished. That's your argument.
Mhm.
Well, Lawrence, I mean, why should I not be punished? I mean, I've killed someone. I've killed someone just like I killed someone in the first scenario where I had able mental faculties. Why should we make a distinction there between punishment?
Because I don't think your mental faculties would be the same as they were in the first case.
So you're saying that in our criminal justice system, we should make some sort of determination differently based on the mental faculties of the individual.
Yes.
Okay. And I'm going to share the results of this poll. This is an interesting one. We were split even more on this one in a way. Again, more people trending towards punishment, but a few more people saying they're not sure. Okay. So again, welcome to Boston College Law School. Welcome to the study of the criminal law. And for those of you who are curious about what a criminal law course may look like, these 4 hypotheticals, as we call them, factual hypotheticals, give you the overview of what an entire criminal course is. I've given you the entire outline of the course just in the opening 10 minutes. We start in this course with the basic elements of criminality, but then we move on to the question, is it murder? That's what I teach in Unit 2 of my course. It's called offenses. I turn back. That's something called inchoate offenses. For example, attempted murder. I drove into the house. That's something that we call accomplice liability or modes of liability. What happens when there's more than one person? How do these questions intersect? And finally, I have schizophrenia has to do with the question of justifications of and excuses. We look at questions of insanity, as the law calls it. We look at questions of self-defense. What happens if my neighbor is coming at me with a gun and then I pull my gun and pull the trigger? How does the law treat those questions? Those are the foundational questions of criminal law and the foundational questions of a criminal law course. This is the course where we talk about the death penalty. And Noor Khan, Noor, are you there? Okay, Virginia Ambilotis.
Hi, I'm here.
Hi, Virginia. Why do you think I assigned the death penalty for this class, for this opening class?
Because it has to do with federal law versus state law, and it's very controversial. And there's degrees, there's like the crime versus like the sentencing and all these different layers.
That's right. So there's crime, there's sentencing, there's federalism, there's federal government, there's state government. But the ultimate answer is the reason why I assigned the death penalty as the opening reading is because the criminal law is the only area of law where at the end of the process, the state can take your life. If in all these other areas of law, property law, contract law, people cannot be executed by the state. But the criminal law deals with violations of the law that are serious, so serious that you could be committed to life imprisonment without parole, or at the extreme, you could be executed. From my perspective, this is what makes criminal law the most important course and the most exciting course in the first-year curriculum. This is the course where we talk about the Capitol riots and how the criminal justice system intersects with FBI investigations around the Capitol riots and the various prosecutions around the country. In this course, we talk about Bernie Madoff and what sentencing is appropriate for someone who's committed his crimes. In my course, we talk about the Michelle Carter texting case. Should someone be responsible if they have goaded someone into committing suicide, or should they not? We talk about Harvey Weinstein and the way in which he was prosecuted for sexual assault. And finally, we talk about, we do all of this in the context of understanding that criminal justice intersects with various communities, especially marginalized communities and communities of color. We are studying criminal law in an era of mass incarceration where we are asking fundamental questions about who should be prosecuted, who should be put on trial, and who should be put in prison, and who should not. Increasingly, as a country, we are asking those fundamental questions. And once you come, if you were to come to Boston College Law School and take criminal law with me or any of my colleagues, you would be equipped with the tools to engage in this debate in a very robustly defined way. So what will we be doing over the course of the next 45 minutes? We began with the opening 4 questions. I'll introduce myself very briefly, just so you have a sense of who I am and also what a criminal legal career might look like, what a legal career might look like even more generally. We'll talk about the death penalty, and then I'll offer some concluding thoughts about studying law at Boston College Law School, which I think is a very special place to study law, and I'm looking forward to getting to know you as we work through all of this today. Before we do, though, I just want to say a word on the subject matter. This is a very difficult course, and the materials that are presented today are very challenging. Those of you who have read it know that. We're talking about murder, we're talking about rape, we're talking about racial disparities when it comes to treatment in the criminal justice system. So I just want to emphasize, I recognize this subject matter is very difficult, and that all of us are coming to this conversation informed by our own experiences. Some of us, most of us, either directly or indirectly have been touched by the criminal justice system, either because some of us come from families or have friends who have been victims of crimes. Some of us have been victims of crimes. Some of us have been mistreated by the criminal justice system, and others of us are conscious of the way in which loved ones have been mistreated by the criminal justice system. So I want to say that I recognize the challenge of that, and I encourage all of us to be respectful as we have that conversation today. Okay, let's move on with introductions briefly before we get into the subject matter. Who am I? Again, my name is Professor Ko, and I'm from Massachusetts, actually. My family is ethnically half Lebanese and half Korean. This is a picture of my family, and this is our dog, Riley, Bichon Frise. We often say that you know, we grew up with a French dog with an Irish name in a Korean, Lebanese, American household. My first introduction to international affairs, which is my other major interest along with criminal law, was when I studied abroad in England. And then when I went to law school, I had a particular interest in international law. I did a human rights clinic in Colombia. I studied comparative law in France. My main mentor was Zambian. I clerked for a federal judge. And then a very interesting thing happened. I graduated in 2008, and my law firm gave me this amazing deal. They said, you should take a year off, and we'll pay you half your salary, and you'll have a guaranteed job on the other end. So I literally had 12 months and a good chunk of change to do whatever I wanted, knowing that there was going to be a law firm job on the other end. So what did I do with my time? I road tripped around the United States. I was a visiting scholar at a law school in Korea. I spent time in Lebanon and studied Arabic. But then I went to The Hague. One of my main mentors said, The Hague is the international law capital of the world. If you go there, you can understand how international law functions in our global order. So first I went to the International Criminal Court, and that's when that's where the criminal aspect started coming into my interest. I worked on cases dealing with genocide, war crimes, crimes against humanity, sentencing. And then for 2 years, I worked for another court in The Hague, which is run by the United Nations, called the International Criminal Tribunal for the former Yugoslavia. I dealt with one of the main cases there, working for the 4 judges. After that, I went to the Department of Justice in Washington, D.C., and I worked on international criminal cases again, but from the perspective of the US government. As many of you know, the Department of Justice is one of the executive agencies, one of the most important agencies in the federal government. This is an internal organizational chart of the DOJ, and you can see that there are different subsections here. So here's the Attorney General up here at the top of the heap, Civil Rights Division, Tax Division. Here's the FBI. I worked in the Criminal Division here, dealing with enforcement of federal criminal law. And within the Criminal Division here, I worked in the Office of International Affairs. So some of you may have seen our news articles about extraditing El Chapo from Mexico, prosecuting Nicolas Maduro from Venezuela, cases dealing with Chinese COVID-19 vaccine research theft. All of these are international cases that I and my office have worked on in the past or are working on now. And during that time, I was also an adjunct professor at Georgetown Law Center and was also a fellow at Columbia Law School before finally becoming a professor of my own here at Boston College Law School. The final thing I'll say about this story is that Boston College Law School is very, very special to me for the reason that I've been connected to BC Law since before I was even born. My grandfather, my paternal grandfather, was a graduate of Boston College Law School, and he was admitted to BC Law by Father Drynan, the very famous former dean, who's a human rights hero, among other things, because my grandfather came to the United States for graduate studies and then was living in political exile from South Korea because the South Korean government was overthrown. So I am sitting here today because of Boston College Law School. My family owes a great deal to Boston College Law School, and I have particular interest in JD students at Boston College Law School because I think of my grandfather as I'm teaching at this school all the time. As a final note, why do I teach criminal law and international law? What I like about criminal law is it's the most fundamental area of law. We're talking about, again, murder, manslaughter, rape, kidnapping. These are the most serious violations of the law, and it really strongly pulls at my sense of justice and morality in a way that I think hopefully it has for all of you thus far today. And I'm also interested in international law because of its questions of universality. What is it that countries can come together and say is fundamentally just or unjust? And that's why I write about things like the International Criminal Court, Nuremberg, El Chapo, Julian Assange, the Mueller investigation, et cetera, et cetera. So if we were in person, I would ask each of you to do introductions, but of course, if we engaged in that, then that would take the rest of the time here. But I can see all of you on my second screen. It's a pleasure to meet all of you. I know Boston College Law School always admits the best of the best. So I know each of you has a unique story. And if and when you come to BC Law, I'm looking forward to hearing from each of you. I make a point of meeting with each of my students for 15 minutes one-on-one at the beginning of the semester. So if you're to come and if you're in my course, I'll look forward to getting to know you more in that capacity. I also just want to recognize two outstanding Boston College Law students in the room right now, John Riley and Rachel Weiss, who are one's a 2L, one's a 3L. They have done excellent, they're leaders in their class. John's my former student, is really always performed in an outstanding way. I welcome the two of them here, and if we had more time, I'd also allow them to introduce themselves. But I want to thank them also for their presence today as BC Law ambassadors. I think their presence is also a reflection of how much the law students here at the law school care about each of you and hope that you come. Okay, let's move on now to talk about the death penalty. Now that you have a better sense of who I am and where we're coming from. Here is a picture of the Bill of Rights. And this is a foundational document in our country, especially the 8th Amendment. Now, in the Bill of Rights endows individual rights on individual citizens. Many of us know this from our studies, from civics, et cetera. And one of these rights is the 8th Amendment. Anastasia Foley.
Hi.
Hi, Anastasia. Now, maybe you've seen the 8th Amendment language before, maybe you haven't, but the 8th Amendment here says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. I want to focus explicitly on this. If I just present this to you and say the Constitution says the federal government cannot inflict cruel or unusual punishment, what does that sound like to you?
To me, it brings to mind issues of like torture, like violating other human rights in the process of punishing someone else.
Yeah, so torture, violating human rights. How do you know? So obviously, if it's, so let me ask you, if all of a sudden the federal government said, we're going to start waterboarding people who've committed crimes here in the United States on a regular basis. Obviously, the US government has done this in the past and it's morally reprehensible. Do you think that would be cruel and unusual punishment?
Yeah, I would consider that cruel and unusual punishment.
What about life imprisonment without parole? Do you think that's cruel and unusual to hold someone for their entire life?
I'm not sure about cruel and unusual, but I personally find it excessive, which I know it's not the language we're focusing on, but.
Right, so excellent, You are asking right now, you have a moral intuition, Anastasia, but you're also saying, what is the actual language? Maybe life imprisonment without parole is excessive, but is it cruel and unusual? That's an excellent question. And I can tell you're already exercising your legal faculties. Now, we're going to not just engage in what Anastasia and I have just done, which is just kind of read the phrase and just engage in our gut intuition. We're going to look at the way in which cases in American law have thought about the meaning of this phrase. And by the time we're done today, you will have a better sense of what constitutes cruel and unusual punishment. When we think about who it applies to, when we think about for what crimes, and when we think about how it might impact different communities differently given racial disparities, okay? Why do we read cases? Cases are a source of law in the United States. So, in fact, why don't you throw up a show of hands? You all know the raise hand function in Zoom, right? Raise your hand if you've heard of the case Roe v. Wade or Brown v. Board of Education. Okay, great. So my screen is filling with raised hands. In fact, I think everyone has raised their hand, right? Okay, you can put your hand down now. Right, so why do we talk about these cases? We talk about these cases in American law because these cases are a source of law, just like the Constitution, just like if Congress passes legislation, executive orders. When the Supreme Court especially, but all courts, when they decide a case, you can cite that case afterwards for that proposition with regard to that interpretation of the law, and it's binding in the future, just like if Congress passes a law. So when we read a case, we want to understand what has the court done. We ask ourselves, what are the facts? What's the central legal question or the issue? How did the case reason through this? What is their holding or their ultimate legal conclusion? And was this case rightly decided? That's an opinion question. And we're going to work through these steps now as we talk about some of the cases the Supreme Court has addressed today. And again, the Supreme Court is, as many of you probably already know, is at the very top of the heap when it comes to our federal judiciary. So the Supreme Court has the final word on the meaning of cruel and unusual. It has a final word on the meaning of the Eighth Amendment, and it's a final word on the meaning of the US Constitution. That's why it's such an important institution. And they specifically do it through the means of what's called judicial review. Courts can review the actions of the legislative and the executive, and particularly they may strike down a law as unconstitutional. Okay. All right. Matthew Zankiewicz.
Yes.
How you doing today, Matthew?
I'm doing pretty well.
Good. Are you doing okay with this online class format? Is it
I don't love it. I don't love it in my undergrad, and I don't think I'd love it in law school, but I'm getting through it.
Okay, good. Well, I'm teaching my criminal law class in person right now. BC has a commitment to teaching in person, at least for some of, every 1L has some in-person classes, and I'm teaching in a socially distanced classroom. We're all wearing masks. We're very safe about it, but we are having the in-person experience. And I know we're doing it over Zoom today, but well, hopefully things will be better in the fall. But even if not, we are teaching in person, at least to some degree. So, so let me ask you, Matthew. Matthew, did you get a sense of, from the reading, who can be executed? Do we execute people under the age of 18, and do we execute the mentally disabled?
No.
And how do you know that?
I read the cases, the Atkins versus Virginia and the McCluskey versus Kemp.
Okay, great. So you're right. You're 100% right, Matthew. Good job. Okay, the Eighth Amendment prohibits cruel and unusual punishment, as we've already heard, and Anastasia's engaged in an intuitive reading of that. Now we're looking at, well, what have the courts said? The courts have said that execution of juveniles under the age of 18 at time of commission of a crime is prohibited under the Eighth Amendment as cruel and unusual punishment. And also execution of the mentally disabled is also a violation of the Eighth Amendment under the cruel and unusual punishment clause. So Matthew, you mentioned Atkins v. Virginia. What happened in that particular case? Did you get a chance to read the facts there?
Yeah, I did. Gail Atkins was convicted of abduction, armed robbery, and ultimately capital murder and sentenced to death. And then he relied on one testimony from a doctor who said that he was mentally disabled. And then from there, he got sentenced to death, and then it got appealed. And then another doctor for the prosecution concluded he was not mentally disabled. He was sentenced to death again.
Yeah, excellent, Matthew. Matthew, you've done an excellent job with that. So that's exactly right? This defendant robs and kills a man in Virginia. He's sentenced to death. But in the evidence below, in the record below, it turns out that he's so-called mildly mentally retarded. That's a term that the law uses, even though that's not a term that we use anymore in our kind of colloquial language. And there's also evidence that he has an IQ of 59. So how is it that the court, let me ask someone else, Jonathan Bertulis Fernand, you're slightly cut off there at the end.
That was a good attempt.
Yeah, okay. Jonathan, how does the court reason that people under the age of 18 cannot be executed? I'm sorry, we're talking about Atkins v. Virginia, that people with mental disability cannot be executed.
I mean, I think it's, let me look at my notes. It came down to the idea that they're not as aware of their actions, so the sort of penological goals of deterrence and retribution aren't really fully achieved.
Yeah, excellent, Jonathan. That's right. So the court has to make cruel and unusual punishment real. The court has a standard of evolving standards of decency, and they're looking at a variety of things. They're looking at whether or not, the direction of legislative change, how many states still allow this and how many don't. They're also looking at, as you rightly said, retribution, deterrence, different rationales for punishment, and they're also looking at procedural protections, right? Does it make sense to execute someone who has an IQ of 59, right? And again, once the court decides, no, the mentally retarded are not eligible for the death penalty, then that changes the law in the entire country. Jonathan, do you think this case was rightly decided?
I was kind of unsure about this one, to be honest with you.
Okay, tell us why. And I'm throwing up a poll question as well to see what people think.
Let me just reread it. Sorry. To be honest with you, I'm having difficulty recalling the exact.
No problem. No, I mean, Jonathan, you're just an admitted student, so this is a very friendly conversation. Mm-hmm. As a general rule, do you think there may be circumstances where, under the Constitution, people who have mental disability should be executed by the state, or do you think, as a general rule, we should not engage in this?
I think, as a general rule, we should not engage in it.
And why not?
Because, I mean, so based on the readings, my understanding was that it would constitute a kind of cruel and unusual punishment because it's not actually achieving the penological goals of a punishment.
Yeah, and you agree with that? It's not achieving the relevant penological goals?
Yes.
Yeah. So, I'll share the results here. We had a lot of, the majority of the class agrees that doesn't meet these penological goals. Retribution is punishing someone for what they did wrong. Deterrence is trying to dissuade others from engaging in this. But some people were not sure, right? And those, does anyone want to volunteer? Who said no on this? Who thought this case was wrongly decided? Anyone want to share their view? I'll take a volunteer. You can raise your hand, or you can just unmute yourself and speak.
I'll jump in and say that it relied on the testimony of one doctor that was then rebutted by a different doctor. Okay. And in both circumstances, the case was decided with one expert witness.
Okay, yeah. Okay, Cooper, so good. So Cooper is asking a question of evidentiary standards. How do we know? And Cooper might also say, maybe if we open up the door to people saying that they have mental incapacity, maybe any person might start testifying that they have mental incapacity, and then maybe avoid the death penalty. So on one hand, we want to avoid things being cruel and unusual. On the other hand, we want to have a space where we're not executing people who don't have the requisite faculties. Yeah, Therese Junot.
Hi, similar to the previous point, I what was it, the psychologist, I was not confident in his justification for calling Atkins mildly mentally retarded. He relied just on interviews with people. It says a review of school and court records and an IQ test.
Yeah.
I think I would want to see more in-depth analysis than that.
Okay. Yeah. All right. So maybe there's not enough of analysis in this case to proceed here. Yeah. Jordan, last word, and then we'll move on to Roper.
Yeah, hi. So I originally voted yes that this was rightly decided, but I'm having a little bit of second thoughts now because part of me feels like in this case where you have like competing experts and you have one expert saying one thing and one expert saying another, that we should kind of defer to the jury's decision in the sentencing guidelines, because I mean two different juries came to the same conclusion twice, that this individual should be sentenced to death based off of everything that they heard. And they had the opportunity to hear from the various experts and weigh that evidence. And so you have the court coming in and overturning two different juries. I feel like maybe we should have a little bit more of respect for the dual decision on the part of those two juries.
Okay, so this is great. So I'm so happy with all of you because these are all different ways of approaching this question. One is, did someone do something morally wrong? Another one is to say, is there enough evidence? That's a different sort of way of thinking about the question. Another one, which Jordan is telling us, is how do courts interact? The Supreme Court is sitting up at the top of the heap of the mountain, but maybe they're in their ivory tower. Maybe we should defer to the determinations that are made below, and we should let the courts have some flexibility in this, right? So these are all great questions, and these are the sorts of questions that we grapple with in law school. Is this case rightly decided? Should cruel and unusual punishment, which could mean anything in theory, how should this apply in this particular case? And Roper v. Simmons, which I'll just say in the interest of time, has very similar issues with this kind of analogous reasoning to Atkins. For those of you who read it probably saw, the court is again kind of drawing on that same type of analysis and kind of asking who is deserving of punishment, right? How are juveniles similar or different? And again, going to Jordan's point, why not leave it to the lower courts? What about the facts of the case? Shouldn't we allow the courts to have some freedom in determining when an individual, whether because of mental capacity or IQ or because of age, should receive the death penalty? There's also a question for you to consider, which we won't talk about today, but just to highlight a question of foreign law, right? Justice Kennedy talks about how it doesn't lessen our fidelity to the Constitution to acknowledge fundamental rights by other nations and people. That underscores the centrality of the rights of the United States. A question you can ask yourself, and a question we debate in law school, is to what degree are we thinking globally about rights? To what degree are we thinking globally about the trends when it comes to the death penalty? Increasingly, the United States is in the minority with the use of the death penalty. Some people say that's a good thing. Some people say that's a bad thing. And some people say the justices should be able to look around the world and compare laws. And some people say the justices should not. They should just keep their eyes on the US Constitution, on domestic considerations. It's another question for us to think about. Okay. Samuel Wynn?
Yes.
Samuel, the casebook talks a little bit about, at the very beginning of the chapter, which crimes can trigger the death penalty. Do we execute people for any sort of offense, just for kind of just regular old, someone just walks down the street and steals a Snickers bar out of the 7-Eleven?
Atkins describes crimes that are particularly depraved, and they found that the average murderer did not fit the bill. So
that's right. So that's right. Yeah. Particularly depraved crimes. And the casebook also talks about on page 56, the death penalty is really only available now in homicide cases, i.e. someone has to have killed someone else in order for a case to be death penalty eligible. There's an exception for treason, but really when you hear that someone's been executed by the state, we're really only thinking about killings. Okay. But Samuel, does that make sense to you? I mean, what about this case here, this Ariel Castro case that's mentioned in the reading? So this is a case, and if you didn't get a chance to take a look at it, that's okay. Very, very difficult facts to talk about, but very important to think about these questions. He pled guilty to 937 counts of rape and kidnapping, holding 3 women captive for a decade. He's sentenced to a life of imprisonment plus 1,000 years, because each of those individual acts triggers more years of imprisonment. He ultimately commits suicide in 2013. So my question is, would you support the use of the death penalty in this case? And are non-homicide cases always less blameworthy or serious than homicide cases? I'm going to open this up to a poll question. What is the appropriate punishment for Ariel Castro? Benjamin Wurzba, which way did you vote here?
I actually voted sort of against my conscience. I voted the letter of the law, which I think in this case probably should have been death penalty, as a very serious crime. But I'm personally against the death penalty, so I can't let that factor in here for the purposes of this class.
Okay, so that's great. So but the letter of the law says that we don't execute someone unless they've killed. That's what we just said. So this guy didn't kill anyone, but he engaged in really, really horrific conduct. So the letter of the law would say you can't execute him for this. Do you think that's right? Should he be death penalty eligible?
Again, as I said earlier, personally, I don't believe that anyone should be. But I think that if we are under the law executing the most egregious of crimes, this would certainly seem to be near the top. Even though it doesn't have the homicide aspect.
Okay, yes, 74% of our class said life imprisonment. So it seems like a lot of our class has this intuition that, we should really not put him to death for this, but he should suffer the second most serious consequence. Does anyone, I'll take a volunteer. Does someone else want to share how they voted on this question?
Yeah, I can share.
Yeah, go ahead. Jelana, yeah, good to see you again.
I voted for the death penalty in this one just because when I was reading through the case, like in the beginning sections when it talked about retribution, I'm just thinking about the 9, I don't know, maybe he raped one woman more than once, but just the victims and making sure that they feel like their voice was heard.
Yeah.
So I think just because he didn't murder someone per se, he caused a lot of harm to these women. And I think that just the 937 counts just shows a very disregard for life that is probably, in my opinion, equivalent to murdering somebody.
Yeah, so that's a great point, Jelana. We need to think about the victims here. Criminal justice is not just about the state going after people. This is about the state providing accountability for crimes that people may not have otherwise. Yeah, Riley Doak, I see your hand raised.
Hi. I never thought that I would vote for the death penalty. I'm from Cleveland. I was in high school in 2013. So this case is a little bit different. And knowing what these victims went through, I thought that the closure that they would receive from the death penalty in this case, despite the fact that it doesn't, based on what the law says, meet that standard, I thought that that would be more just.
Okay. All right. Great. Okay. So I think this is great. People are challenging their intuitions here, and we're really starting to become more systematic, rigorous thinkers about when the death penalty should apply and when it should not apply. And again, these are the sort of critical skills that we build in law school as we work through these cases. A lot of times we kind of default to our intuition, but now we're actually defaulting to our legal experience. And I love that there's other hands raised. I want to get to more people, but I also want to make sure that we cover the final question of racial disparities with the death penalty, which is a critical question in our society today. And I want to tee that up with a quick video that's ripped from our headlines. I can still see Jelana on my screen. Jelana, you can see this, right? The video?
Yeah.
Okay, great. And can you just give me a thumbs up if you can hear the audio once I start playing?
Sure.
Thanks.
A federal prison in the United States has carried out the execution of a convicted killer, Brandon Bernard. The African-American man was part of a gang who abducted, robbed and murdered 2 white youth ministers in 1999. Well, he's the 9th federal inmate to have been put to death since July. More federal prisoners have been executed in the US this year than in the previous 56 years combined. Lebu Diseko has this report.
Brandon Bernard had been on death row for the last 20 years, and on Thursday he became the first federal prisoner to be executed during the presidential transition. It's one of 5 that are scheduled. If the rest go ahead, Donald Trump will have overseen the deaths of 13 federal inmates since July this year, more than any president in over a century. The federal death penalty was reinstated in 1988, but executions were rare. Just 3 had taken place since then, and none since 2003. But in July, the Trump administration resumed the practice after a 17-year hiatus. Brandon Bernard's case had attracted the support of celebrities like Kim Kardashian West. The reality star and prison reform activist had called on her followers to tweet Donald Trump to save Mr. Bernard. And tomorrow, another federal execution is scheduled at the same penitentiary in Indiana. These executions come just weeks before Joe Biden takes office, and he has said that he will seek to end the death penalty. The incumbent president would usually defer to his successor and let the president-elect set the course. But Donald Trump's attorney general says he is just following the law. He says he owes it to the victims and their families to carry forward this sentence. Lebu Diseko, BBC News, Washington.
Okay, so I show this to kind of underscore just how it is that all of these different cases are very much arising in our news. And I also do this because it shows the power of criminal law and being a law student to kind of understand how it is that these cases are unfolding. And I do this in order to show, it's because it interfaces very well with McCleskey v. Kemp, which is one of the most controversial cases in the history of the US Supreme Court. Sarah Cicchetti? Sarah, just in the interest of time, can you tell us what the central statistical finding was by the Baldus study? And did the court find that there was a constitutional violation given the disparities that were found in this particular case?
So the central finding was that if the victim of a murder was white, there was a 4.3 times higher death penalty ruling.
Yeah.
And the court did not find that that was a constitutional issue. They found that this took place in Georgia. They found that the court system in Georgia was impartial and could operate in an objective way.
That's right. So excellent job, Sarah. So this is the Baldus study, and this is another one of the studies from the same individual. This is from a different point in time, but showed the race of the defendant, the victim, in combination with role in prosecutors, and multiple findings showing disproportionate use of the death penalty on Black defendants, especially when white victims are killed. Right, just like in the Bernard case that we've just seen from just the end of the Trump administration. And the court ultimately, as Sarah told us, rejected discriminatory claims, saying this did not amount to a constitutional violation, either under 14th Amendment due process and equal protection, but also under the 8th Amendment. In other words, this was not cruel and unusual punishment. This was not disproportionate. This was a discrepancy that appears to correlate with race. So let me ask this question to all of you. Was this case rightly decided? Okay, and I'll share the results. Almost half the class said no. A lot of people said they weren't sure. And a few people said, yes, rightly decided, right? And I'll take one volunteer who wants to give their view on this. Again, acknowledging this is a very difficult issue to discuss. Yeah, Del Smith, go ahead.
Yeah, hi. So I went with yes, but it went against my intuition. The biggest thing for me was when the court basically said that the Baldus study kind of applied to or it held up against like jury selection, and I forgot the other example they used, but in this case, for McCluskey to claim that he was discriminated against was a far stretch, because each case has different facts and all of that. And also the point that stuck out to me was the court said, well, if this was the case, the Georgia State Legislature has more than enough ability to put a new law in place that bars discrimination as well.
Right. So the court's saying there's a case-by-case analysis. The states may do things differently, and for Dell, that's persuasive, right? And if you come to BC Law again, if you're in my class, this is a case that we debate very fully in class, because for those of us who are concerned about criminal justice and systemic racism, this case in some ways is ground zero for thinking about this question, because essentially what the court does is it says there's a correlation, but correlation does not mean causation. And the individual defendant has to show racism, and it has to show racial motivation in every particular case. But for those of us who are aware of the fact that we're living in an era of mass incarceration, this case is very infamous for insulating. For those of you, how many of you, show of hands, have heard of or read this book, The New Jim Crow by Michelle Alexander? Yeah, so a bunch of people. So Michelle Alexander famously said that this case immunized the criminal justice system from judicial scrutiny for racial bias. And the case was a so-called 5-4 decision. So just very, very narrowly, the court decided against the defendant. But Justice Powell, later on in his career, said if he could have changed any vote, he would have changed the vote in McCluskey v. Kemp. Okay, so when I teach, I always, to be clear, I always finish by sharing my takeaways for my students so they know exactly what we've covered and they have a sense of exactly where we've been. Again, today we opened with 4 hypotheticals, and I introduced you to what a criminal law course may look like. I also did introduce you to myself. We talked about the death penalty, and the kind of critical takeaways are that a 1L criminal law class asks foundational questions about the definition of crimes, the nature of punishment, and the scope of criminal liability. The death penalty highlights the high stakes of criminal law. It does not now apply to juveniles or the mentally disabled. It applies only to homicide, and applies despite the fact that there are racial disparities. And the final case in particular underscores my attitude when I teach criminal law is to rigorously understand the function of criminal justice. We must be careful and attentive to how it intersects with race, class, and we also talk in my course about gender, sexual orientation, disability, all other aspects of American society. And just as a final word before I turn it over to Dean McShay and or take any questions, is just, as I said, with regard to Boston College Law School and studying law more generally. First of all, when it comes to the power of law, I think a lot of you are here because you sense during these turbulent times that law equips us to understand why systems, whether it's governments or other systems, are working the way they do. And I think many of you are hungry for change and ways to make change. Well, the way to make that change is to learn the power of the law, learn the language of the law, and then you may be the one arguing in front of the Supreme Court to change the way the death penalty is applied. Now, others of you may have no interest in criminal law. You may care about environmental law or corporate law or law relating to the music industry, entertainment law. The list is endless, but the unifying thing with all of them is the power of the law and the power that you will gain by studying the law. And finally, I'll say, I have studied law at a variety of law. I've studied law and taught law at a variety of law schools around the country. And I think studying law at Boston College Law School is truly special. In addition to having the highest quality students, faculty, staff, administrators, we also have a commitment to a Jesuit tradition that is oriented around service to others. And we have an emphasis on community. I think Rachel and John, who are here today, and many others will say that Boston College Law School is a law school where students and faculty talk amongst each other in a very open way about the law. Students talk with each other in a very open way about the law. And this broader tradition of service to others, I think, makes it a truly special place to study the law. So with that, I want to thank you for being here. I hope this gave you a sense of what it's like to be in a legal classroom. You all did an excellent job, despite the fact that you're not law students yet. I know it can be very intimidating to be called on, even over Zoom. So I'm grateful to you all for your attention, and I hope to see you in the fall. I'll turn it over to Dee McShay.
Thank you, Professor Coe, and a special thank you to each one of you. Wow, you were amazing presenting in class today, so thank you for joining us. I want to reiterate, Professor Coe, in that I hope you enjoyed your class, and also highlight some of the points that he just made. You heard Professor Coe just mention them, but for those of you who participated in our opening session last week, you also heard Dean Rougeau speak to the 3 pillars of BC law: leading with educational excellence, with experiential learning opportunities in the great city of Boston. He spoke about our diverse and caring community, and he spoke about our commitment to student formation and social justice. Today, you've just experienced what student formation looks like in the classroom. And so now I want to continue and invite you to continue this journey with us by registering for week 3 and week 4 of our Admitted Student Month. Week 3 will focus on our community, which is told through the lens of a student perspective. It'll start with a 20-30-minute panel, and then we'll go into one of our infamous BC Law trivia nights, and that's going to be a wonderful opportunity and some great prizes there as well. And then for week 4, which is the final event for our Admitted Student Month series, we're going to go into Careers in Focus, which will focus on an alumni panel, and then we'll have a networking event with faculty, current students, and additional alum. The registration for those events are now open. Feel free to visit the virtual events on the Admitted Student page. And then finally, I want to reiterate that we are continuing to release scholarship decisions. It is my hope that I will have all of the scholarship decisions released within the next 2 weeks. So thank you so much. Our first deposit deadline is April 15th, so that'll give you some time to talk with us and still consider all of your additional options. But I hope after all of these experiences and the more connected you get with the BC Law community, that ultimately you do decide to join us. We'd love to have you be a part of this community. Thank you and have a wonderful and safe weekend. Take care, everyone.